Assalamualaikum warahmatullahi wabarakatuh. My name is Helmi and I'm representing my team members. So today I'll be sharing with you findings from our research entitled Decoding Orphan Works Policies, Lessons from the European Union, the United Kingdom, Canada and India. And our research is basically legal research focusing on this specific topic under copyright law, which is called orphan works. So orphan works is basically a work, or in Bahasa we call it as a karya, like movie, books, songs. So these works are basically, they are still copyright protected, but the prospective users, iaitu pengguna, they are unable to reach or to communicate or to locate the copyright holder of these works. And it's basically a problem because the requirement of consent for use from the copyright holder is essential before we can use somebody's work. Otherwise, it would be in an infringement of somebody's right. And that's why when we explore the literature on this, we found that most strategies and mechanisms are focusing on legal mechanisms. For instance, the use of fair dealing defense, fair use defense, and the use of a specific exception for the use of orphan works. But the trend to explore this area from the perspective of the policy measure is not so popular. So this became the motivation for us to, I would say, to fill the gap, i.e. to explore what are basically the strategies from the policy perspectives in addressing the situations with orphan works. So this is the main question that we are going to answer. What are the main points that we can learn from the EU, UK, Canada, and India? And why these four jurisdictions, the EU, UK, Canada, and India? The justification for that is these jurisdictions have already in place the policies, the the law in addressing the orphan works problem in their jurisdiction. So they are basically role models when we talk about orphan works situation or scenario, and that's why we opted these four jurisdictions in order for us to look into their policies when they want to address the orphan works problem. And before that, in order to undertake this research, we adopted policy analysis because for obvious reason, because we want to look the policy strategies in addressing this particular scenario. So we're looking into the policies of orphan works from the perspective of their aims, their principles for exploitations, and the main strategy in permitting the use of orphan works. And in addition to policy analysis, we also use library-based research in order to understand certain basic concepts for this particular study. Now, what is meant by orphan work? So when you talk about orphan work, this particular terminology has nothing to do with the concept of orphan children. So we don't want to create a misunderstanding or misconception. Orphan work is basically a special word in, or special phrase in copyright law, meaning it is a work that is still copyright protected, but the users, for instance, individual users, company, or businesses, they are not able to communicate, they are not able to identify or to reach the copyright holder of the orphan works. Hence, these works are called orphan. Well, to some extent, they might perhaps mirror the concept of orphan children, but a more specific application in the copyright world, it's basically when a user, like us, prospective users, they are not able to actually get in touch with the copyright owner of the work, because um, when they want to use somebody's work, obviously we would have to get the permission or consent, prior authorizations from the copyright holder. Otherwise, it's going to be a copyright infringement. So basically, these are the unit of analysis. These are the policies. One thing to note is that the policies are not documented in one single policy. So these are basically scattered documents discussing about the orphan works issue in their jurisdictions, and henceforth we believe that even if they are not documented in a single place called an orphan work policy, but it's very important for us to actually go through all these orphan works related policies in order to understand their approaches from these four jurisdictions. And the findings, when we studied and examined these policies, so we found three important findings. So when we talk about the aim of the exploitation of orphan works, all policies believe that we must permit the exploitation of orphan works because we want to disseminate knowledge or inhibited values from the orphan works. So that's why we have to permit the use of orphan works. Finding number two is, in order to do that, we have to be able to apply the principle of openness. So the and this is very important because it relates to finding number one just now. So we have to promote dissemination of knowledge by implementing the principle of openness in order to promote free movement of knowledge and innovation in the regions. And most importantly is the principle of adherence, because this is where we want to protect the rights of the copyright holder. So we are not going to just let someone to use somebody's work without imposing on them the conditions to find the copyright owner at first place. So they still have to find the copyright holder before they want to use the works. And finding number three is about the strategy to permit the exploitation of orphan works, and especially in UK, Canada, and India, they permit the use of orphan works through a mechanism through licensing scheme. And in summary, if we go back to the research question, what are the main points that we can learn from the EU, UK, Canada, and India? We found that these jurisdictions are very committed in addressing the orphan work scenario, and we can notice that they provide a balanced approach to this problem, i.e., at one point they want to support dissemination of works by permitting the prospective users to use the works, and at the same time they want to protect the rights of copyright holders as well. And that's why we want to implement the principle of adherence. We want to ensure that the prospective users must be able to locate the copyright holder before they proceed to use the orphan work. So they are actually providing a balanced approach to this orphan work situation. So moving forward, especially in Malaysia, we still don't have a specific legislation, specific solution for orphan works problems, and that's why we advise the prospective users to conduct diligent search when they want to use somebody's work, and to properly record and document the search result. And this is especially important when you talk about commercialization activities, because that's where you means the prospective users gain some kind of monetary benefits from the use of somebody's work. And that's why it is very important for you to conduct diligent search, record the search result properly, because in the future, if there is a problem with your activity, then we can actually defend ourselves that we have tried to locate the copyright holder before using the work. So thank you very much for listening to our very short presentation, and a special acknowledgement is also given to Geran Dana Dalaman Negeri Collaborative Research Seed Fund by UiTM Negeri Sembilan for their financial support, and special acknowledgement to my team members as well. With that, Assalamualaikum warahmatullahi wabarakatuh, and have a good day, everyone.